Welcome back to TV5 News at 9. It's time for Legally Speaking with family law attorney Matt Hewitt. Matt, thank you so much for being in with us this morning.
Thank you so much for having me.
Yes, so today we're talking about estate planning, and we have a few topics to touch on. So we hear the term ladybird used a lot. So what is ladybird deed, and do you recommend that people actually use these?
Absolutely. Thank you. That's a great question. I get asked that probably almost every time I meet with someone about estate planning. Seems to be the topic everybody is talking about right now. And what a ladybird deed is, it is a quitclaim deed, sometimes called an enhanced life estate deed. Fancy lawyer words, but what it means is it allows you to put someone as the beneficiary or the recipient of your house upon your passing. The benefit is it allows you to avoid the costly and time-consuming probate process, make sure that the home gets to who you wanted it to quickly and efficiently. Basically, all you have to do is record a $30 death certificate and the property becomes the person you left it to. The other really nice part about this, and the thing everybody's concerned about, is it protects your home from Medicaid reclamation. That's that process everyone's worried about, that if you've ever received benefits like a nursing home, the state could potentially recover what they've paid for you from the value of your home. This allows you to avoid that, so it becomes just a wonderful tool, makes for a very efficient transfer, but it also protects your asset.
Yeah, and I was going to say, it seems like it just helps to make the process a bit easier, right?
Absolutely, yes. It's incredibly easy. And the other nice thing is, it's very cost effective. It's a simple deed, so it's not like the really expensive process. A lot of people are worried about how expensive an estate plan can be.
Yeah, so many people have heard the best way to protect their assets is through a trust. So can you have both a trust and the ladybird at the same time?
Yes, and so this is where some of the confusion comes in. 25 years ago, everybody heard, oh, you need a trust. It's the only thing you can have, right? And if you don't have a trust, somehow you are deficient. Not true. But what's nice about it is the trusts are still very, very effective, and they allow for you to be able to control the distribution. Maybe you have a young child, or you have someone who's perhaps not financially responsible. So the trust allows you to slow that distribution down and to control that. What the ladybird can be used with the trust. So instead of leaving the property to an individual, you would leave it to your trust the same way. So it still avoids the need to go through probate, and it still gives you the benefit of avoiding Medicaid reclamation, but you get the bonus of having all the benefits of the trust.
So would you tell us that a trust is still the best way to proceed with an estate plan, or no?
It is still a wonderful tool, but it is not for everyone. And so unfortunately, I get some people who are afraid to consider an estate plan because they're so worried they've heard about the cost. It is the gold standard, it's wonderful, but it is not necessary for everyone.
So you talked a little bit about beneficiary designation. Can you tell us what beneficiary designation is?
Sure. So beneficiary designation is one of those things, if you've ever had a life insurance policy, it says, give this to someone upon my passing. Now, most financial accounts have the ability to do that. So if you have a 401k, a 457, a 503, or any other number and letter combination, you can generally put a beneficiary on that. What's important is make sure you check those beneficiaries probably once a year. We've all heard in like the time change, check your batteries and your smoke detectors. I tell people at Valentine's Day, check on your loved ones. Make sure that your beneficiaries are in place, because sometimes computer glitch can happen, your wishes have changed, anything can happen, and maybe the beneficiary isn't right or it's been lost. So we always make sure to check those. What that does is make sure that your loved one gets that asset immediately. They don't have to go through probate. They don't have to wait. They don't have to incur any cost. And the beautiful thing is, they're free to do.
So can people still achieve that by just joint titling their accounts with their children, or is that something completely different?
It is something completely different. And joint titling is an old school way people used to do, because again, it was free to do. But it came with so many dangerous side effects. And when you joint title with someone, you really lose control, potentially, even during your life. So I really recommend avoid doing the joint titling. If you're wanting the property to get to your children or a loved one, just do it through beneficiary designation. Don't do it through joint titling.
Yeah, and we spoke a little bit about just making sure that our beneficiary designations are up to date. Can you just reiterate how important that is?
It is so important because what we have found there are times where people have forgotten, and the courts have ruled that if you've listed someone, that's who gets it. That's number one. So we had a case not too long ago where a person went through a bad divorce and they forgot to change their beneficiary. They thought the divorce decree changed it, and it didn't. And when they unfortunately passed away, everything went to their ex-spouse. That's one problem.
Ooh.
But another problem is I had one where grandma left to daughter. And daughter and her brothers all got along. And so when the money came in, she said to her brothers, hey, let's get together in a couple of weeks and we'll divvy the money up. There was no issues. Unfortunately, daughter passed away unexpectedly before she had shared it with her brothers. Now, her children said, sorry, uncles, we don't care what grandma said. So that was a case of good intentions that went bad. So this is why joint titling is not effective and bad, but beneficiary designations, we wouldn't have had that problem. And those brothers would have received what their mother or grandma had wanted.
Yeah.
So it's very important to make sure that you keep those up to date. Very important we don't do the joint titling.
Yeah.
And so the best thing you can do is sit down with an attorney. Most attorneys don't charge for consults, and you can really figure out what's necessary for you, because there's no such thing as a one-size-fits-all estate plan. Each person has unique aspects. Their assets are different, their loved ones, how they want to handle it, how they want to take care of their kids. And it makes a difference between the ages, too. If you have young children, your plan's going to be very different than if you have adults that you're leaving it to.
Yeah, and those examples that you just gave of just different cases of where they didn't put the beneficiary, that should be a wake-up call for everybody, honestly.
I hope so. I hope so. And at the end of the day, that's what we really want to make sure is that we are protecting you.
Right.
And it's very easy to do. It's just, you just have to start.
Yeah, sit down and do it.
Yeah, yeah. You know, Zig Ziglar used to say, you don't have to be great to start, but you have to start to be great.
There you go.
And so it's the same thing with estate planning. You don't have to have a huge estate to start, but you should start planning because everybody has something.
Yeah, everybody has something. I just love the way you put things together. Thank you so much for being here with us today.
Thank you so much. It's a pleasure.
Yes, Matt. All right, so you can find more information in the hot link section of our website, WNEM.com.